cooperation, which we've touched on throughout the morning actually, which has been interesting, and hopefully this well-informed panel will round things up for us. I will just briefly introduce the panel members to you, although obviously their bios are all in the pamphlet in front of you. So I'll start with Anne, who's joining us from the registry at the ICC, and she is the Judicial Cooperation Advisor, and she will be discussing how the registry of the ICC supports defence cooperation requests. I then have Brent, so to my right. I will read out Brent's bio because he was a late but welcome addition. So Brent started his career in ICL, like so many of us, with an internship in the defence at the ICTY back in 2007. That internship led to an immediate job which saw him support counsel in 2 defence teams on ICTY cases, and then Brent has worked in chambers and registry at the ICTY until 2011, before moving on to the STL, and then private practice, and you're now at the registry at the Mechanism. Then to my right, I have Kate, who's joining us as the Director of the Hague Office of the IBA, and she will be discussing IBA State Cooperation Guide that was introduced. Then we have Kinga, who is specialises in ICL, has been around at the STL, and also the Kosovo Specialist Chambers, and she will be discussing UNITAD this afternoon. And then we have Phil, who I'm not sure what more to say, Phil. I think you've introduced yourself plenty today, but he's been before ICTR, STL, ICC, MICT, and so on. And he'll be discussing issues of cooperation before the Mechanism. So we'll start off, I think, with Kinga, please. And then, so I know you all have questions, but if we can hear each of the panel members, and then I'll open the floor up for questions. So, Kinga, over to you.
Thanks, and good afternoon. Can you hear me?
You just
Right, good afternoon. Thank you for the invitation. Thank you for this great opportunity to talk about UNITAD today. UNITAD's rise and fall is very much connected to cooperation, although not necessarily cooperation with defense and defense council, but with host states and third states. So as the panel's topic is today, I'm going to talk about the successes and the challenges and ultimately the failures that led to UNITAD's premature closure. Of course, what I'm about to say reflects my personal opinion and not that of any organization I work for. So, a very brief overview of what UNITAD was. It was established in 2017. It was the first non-judicial accountability mechanism established by the Security Council under Chapter 6 and at the request of the host state and within that host state. The mandate of UNITAD was to support domestic efforts to hold ISIL or ISIS accountable, and to this end it was mandated to collect and preserve evidence of acts that may amount to war crimes, crimes against humanity, or genocide allegedly committed by ISIL. Now, interestingly, the primary intended recipient of this evidence was to be Iraq, the host state. But UNITAD was also allowed to share with third states as long as Iraq was informed thereof. It had 2 main operative pillars, the Office of Field Investigations and the Office of Evidence Management. Under the Office of Field Investigations, there were 6 units that investigated across the various communities of Iraq, so Shias, Sunnis, Yazidis, Christians, and so forth, and 2 thematic units concentrating on gender-based and financial crimes, respectively. Under the Office of Evidence Management, you had several units, and the forensic and digitization units were the most important, which I will mention a bit later. UNITAD closed its mandate on 17 September this year at the request of Iraq and pursuant to a Security Council resolution adopted in the same month. I think the slides are down. Well, actually, I can continue meanwhile while this time's up. First, I will talk about some of the successes of UNITAD. So, well, first of all, it was in a very, very friendly setting. It was based in country, in Iraq, with a very friendly host government, with judicial authorities that were keen to cooperate with the investigators, with most victims and affected communities open to share their stories, with civil society organizations very keen on cooperating with UNITAD. So, in fact, in the beginning, investigators had almost unfettered access to records, witnesses, and sites. There were some delays, of course, and occasional refusals, but the work of the mission was actually in a very friendly and very work-oriented context. And this actually led to some of the main successes of UNITAD, and one of them is the work of the forensic unit that assisted in the mass grave excavations of 68 such graves, together with the Iraqi authorities. The work of the digitization unit that turned court records, Iraqi criminal court records, into digital format. And the work of the jurisdictional support unit that answered more than 300 requests from third states for assistance in various domestic proceedings of ISIL perpetrators. And here I will say something in brackets. UNITAD had a policy also to assist defense requests, but only in already existing cases that were already in front of a judge, and only if the same evidence was already shared or was being shared with the prosecutor. I'm not saying that the policy is ideal, but it was actually more that, for instance, what the IIIM does, that does not share at all with Defense Counsel and Victims Counsel. However, there was never an independent request for a defense counsel for assistance in any of these domestic proceedings. Most were from prosecutors or investigative judges. No? Okay, I can continue. So this actually leads me to the challenges. What were the challenges with UNITAD? Well, while it was very successful in assisting third states, until the very last months of its existence, it shared almost no evidence with Iraq, the host state. And as you remember, I said in the beginning, in its mandate, it is stipulated that Iraq is the primary intended recipient of the evidence collected by UNITAD in Iraq. Why was this approach adopted? So according to the resolution that formed UNITAD, Resolution 2379, and its terms of reference, certain conditions were interpreted by UNITAD leadership. I think it's this one, sorry. So yeah, this was the successes, I discussed this, and we are now here with the challenges. So in order to share evidence with Iraq or third states, UNITAD leadership put together a list of caveats, like in what cases can they share evidence. And I'm going to talk about two of these caveats, which are very important in relation to Iraq. One was that evidence was only to be shared with national authorities that had the jurisdiction and competence to hold ISIL accountable for war crimes, crimes against humanity, or genocide. Meaning, they could only share evidence with states that had these three international crimes incorporated in their domestic legislation and could actually prosecute on their basis. And the second caveat, which is very important, is that evidence was to be shared only for use in fair and independent criminal proceedings. This was language taken from the terms of reference. So on this basis, UNITAD never shared any evidence with Iraq until the very last few months, because Iraq doesn't have a domestic legislation incorporating war crimes, crimes against humanity, and genocide. They have an anti-terrorism law, which is quite broad, and which was of quite a lot of concern to the UNITAD leadership because it has a very broad interpretation of what a perpetrator is, and it prescribes the death penalty to quite minor terrorism-related offenses. So, as you can imagine, because of this, the relationship with the Iraqi government slowly deteriorated. And what didn't help was that UNITAD worked very closely with the Iraqi judges, meaning they were receiving a lot of records from the Iraqi judges, not giving anything back, to the detriment of the relationship with the central executive authorities, who ultimately were the decision makers when it came to the extension of the mandate. Another challenge was the relationship of UNITAD with other UN entities. UNITAD was created as an independent investigative mechanism. It only had the obligation of a biennial report before the Security Council. And this independence was, of course, needed for the work that it was doing, but it also meant that there was no coordination in its relationship with Iraq, on one hand, and its relationship with the UN Secretariat or UNAMI, the Iraqi-based UN mission. And this led to the fact that the UN Secretariat had clearly a very different view on the sharing of evidence with Iraq. The UN Secretariat constantly pushed for a more creative approach, for rereading the terms of reference in a way that allows sharing of evidence, and there was room for that. In my personal opinion, there was room for that because the same terms of reference talked about the broadest possible use of the evidence. They talked about assisting Iraqi investigations, complementing Iraqi investigations, and it did not, word by word, connect domestic efforts to hold ISIL accountable to the existence of the legislation, the way UNITAD actually interpreted this. So, because of this situation, because of the constant refusal to share evidence and UNITAD waiting for Iraq to adopt a law on international crimes, UNITAD also assisted to a certain extent the drafting of this law, which actually never materialized, that was never adopted by the parliament. This led to a complete breakdown between the relationships between UNITAD and the Iraqi government, and led to the adoption of Resolution 2697 in September last year, where at the request of Iraq, the Security Council decided to extend the mandate for 1 year only. Now, this resolution was received with incredulity at UNITAD. Everyone became overnight an expert analyst of the word only. They all thought only meant maybe. And there was this general belief that with a bit of work and some different kind of engagement and communication, the Iraqis are going to change their mind because they always change their mind. And as laudable as this plan A was, its disadvantage was that there was no plan B. What if they don't change their mind? And because of concentrating on plan A for the first 6 months after the resolution was handed down, there was no completion strategy. There was no plan of how long operations should continue, should they all stop at the same time, should some stop earlier than others, and crucially, what happens to the evidentiary holding once UNITAD ceases to exist. Because of these delays, and because no plan was made, it led to a situation where UNITAD was forced to share evidence with Iraq, as requested by the resolution. And lo and behold, all those arguments I mentioned to you earlier, that there could be a more creative interpretation, they all came to life, and suddenly sharing with Iraq was possible, subject to information provider consent confidentiality considerations. I am not going to sit here and say that all the redactions that UNITAD applied were necessary. Those of us who have a defense background, we all have a nervous twitch when we hear the word redactions. But you can imagine that going from no sharing whatsoever to finally identifying categories of evidence that could be shared with Iraq was quite a lot of progress. But of course, it was too little, too late. And the Iraqis did not change their mind. And UNITAD closed down on the 17th of September this year without any of its work being finalized. Some of the investigations were in quite advanced stage, but none were completed. And that also applies to the mass grave excavations. Lots of mass graves left unexcavated, and also applies to the digitization work that was supposed to be finished and was never done so. Crucially, and I think, yes, this is the biggest unmitigated failure, the complete evidentiary holding of UNITAD ended up in the UN archives, which does not have a jurisdictional support function or capacity, meaning that it is basically buried there. 52 terabytes of evidence collected are buried there without, of course, we can all go and put down requests, but it's an archive. They take time to respond, and they don't work as a jurisdictional support mechanism. And this, I would not put this on UNITAD. The last special advisor of UNITAD made considerable efforts to establish something, but as I said, this process started a bit too late, and there was no political will to establish such a residual or mechanism or entity. And one word of caution, this actually doesn't only affect UNITAD, it affects all investigative and fact-finding missions out there. None of them have a plan of where the evidence should go after the mission ceases to exist. I think the fact-finding mission on Iran has a plan that the evidence goes to the UN Human Rights Council Secretariat, which has exactly the same problem as ARMS in New York. They don't have a jurisdictional support capacity. Last slide? No? Maybe? Oh, that was not the last slide. Yeah, I'm done actually. Okay, so why do I call it a cautionary tale? It's because it started so well. It started like the perfect setting. It was the mission in the country, in a friendly country, to investigate a terrorist organization everyone hates. But because of how the mandate was written and then how it was interpreted, and because of the choices made in how to engage with the host state and third states, it actually led to a premature closure of this entity without having finished its work and with its evidence ending up in an archive. Is there any hope? Well, my hope is that it does not act as an ultimate deterrent for the establishment of similar missions in the future, and there is actually still hope for the creation of that mechanism that could take over evidence collected by other missions, other fact-finding and investigative missions, and perform a jurisdictional support role. And that was all from me. Thank you very much.
Thank you, Kinga. And maybe something we can discuss later on, but it sounds like a lot of self-imposed conditions that led to its own downfall. So maybe something for us to discuss later. But if I can now pass on to Kate, we can discuss state cooperation and recommendations, I hope, for states.
Yes. So good afternoon, everyone. Thanks so much to the ADC for inviting me. And as Sarah said, I'm here as not a PowerPoint expert, so bear with me, on behalf of the IBA Hague Office and ICC and ICL program. Just taking advantage of having a room of international criminal lawyers here, there are ways you can engage with the IBA through our War Crimes Committee, our Human Rights Law Committee, and a personal plea to come judge at our moot court, which takes place in June in The Hague, where we co-organize it with Leiden University, and we love to have criminal law experts as judges. That is all there. Our program has been based in The Hague since 2005. Our mandate is to increase cooperation and support for the ICC and other accountability efforts. You can read more about us on our website. What I'd like to draw your attention to in this context is the history the IBA has, including with the expertise and cooperation of many people in this room, of monitoring fair trial issues at the ICC. And seems apt somehow, and providing recommendations to the ICC and to states parties for how to improve fair trial considerations and strengthen the rights of the accused at the ICC. So these are all available on our website, and provisional and final release, long-term issues in international justice, the need for institutional support for the defense, the need for a defense office, and cooperation have all been covered in our reports over the years, and we have been making these recommendations to states parties for many years and to the court. This is delightful. Okay. So, I want to today talk about our latest initiative, which is which is our guide for states parties. And so this is a document. There were some out in the front. You can find it online. It's a quite lengthy document that we did after we gave input to the ICC's independent expert review. And the independent expert review was created because states parties wanted to improve the performance of the court. They had questions about how the court could be doing better in their work, and we gave input on that. But we also thought, this is really about the states parties as well. How can the states parties be doing better on their part, which is effective oversight of the ICC, having effective national frameworks to fulfill their own statute obligations, cooperation and complementarity frameworks, promoting universality, and protecting the court from political attacks. So those are the areas that we cover in this report, and that's what I'm going to focus on today. It's really taking a critical look and providing recommendations. And I want to focus on our recommendations in 4 areas on national legislation to support cooperation with the defense and cooperation generally. So I'll talk a little bit about what states parties can and should be doing, and then I also want to spend a little time on what else can be done. So just to briefly center us on the cooperation framework, we all know it's in Part 9 of the statute. There are the obligations to cooperate, requests for cooperation, the general provisions. I won't go into it in detail, but importantly, the voluntary cooperation agreements, which we've talked about quite a bit today already, the impact of not having those. There are 4 areas in which the court requests these framework agreements: witness and victim protection, enforcement of sentences, provisional release, and final release. And the rate of conclusion of those framework agreements, even though they create no actual obligation on states to accept a specific person, has been abysmally low. So we've already had discussion about the impact of that, but I just wanted to mention it because we can see already some of the weaknesses of the cooperation framework in the statute. The fact that these are voluntary agreements, but they're about essential functions of the operation of the court. How do we know how cooperation is going? Well, you all know from your own cases, but the court, and I'll say very little about this because we have Anne here, does produce a report on cooperation to the Assembly every year, and we always find it very useful. In fact, we love to, when it's more explicit, it's more useful, to understand from the court's perspective, how is cooperation going? What is the rate of return on the requests for each area where the requests are being made? And what's influencing cooperation and the rates of cooperation? And I just want to draw your attention to one of these factors, which is the lack of internal mechanisms within states. And that's really what we focused on in our guide for states parties. So, 4 different areas that I want to focus on. The first area I want to highlight have to do with the fundamentals of cooperation and how states can prepare for it. And one of the really key recommendations we made is the need for states to enact standalone cooperation legislation to ensure that their national authorities can cooperate with the ICC specifically. And that's because the obligation to cooperate with the ICC is distinct from other cooperation obligations they might have with other states on criminal matters, or indeed with other international criminal tribunals. So what you really need states to do is pass legislation that specifically deals with the ICC obligations. Another important recommendation was you have to review this legislation periodically. If you passed it 20 years ago, which wouldn't that be wonderful, the court may know better what's needed. There may be changes that need to be made. It could be sharpened up. So we recommend that it be reviewed every 10 to 15 years. And then another recommendation is that ICC officials, staff, and counsel should be allowed to be present or assist in the execution of requests for cooperation. And this is really important because there's, to some extent, it's really hard to tell, especially for us as civil society, that how are things going, what's going right, what's going wrong, what can be improved in the processing of cooperation requests. The next set of cooperation requests I want to talk about is ensuring that defense and victims teams are explicitly included in the legislation. So it's asking states parties to ensure that not just the ATP, but the defense and victims legal representatives can conduct investigations on their territory. And then related to that, and very importantly, as I'm sure you all know, the Agreement on Privileges and Immunities, or APIC, which has not been universally implemented by ICC states parties as an understatement. So incorporating this into national law is really essential to ensure that people can do their work on the territory of states parties. And the APIC is also becoming, as I'm sure you know, very important in the legal aid discussions as a possible route to addressing the taxation issues for external counsel of the court. So a very important agreement that doesn't get as much attention as maybe it should. The third set of recommendations I want to highlight have to do specifically with explicitly ensuring that the defense can have specific procedures available in national legislation to address their requests. So Article 93 has all of these specific areas where cooperation is requested, and our general recommendation is that national legislation have all of these explicitly included, not only for the prosecution, also for the defense, and also for victims' legal representatives. And that's just to make sure that it's absolutely clear and that it is the defense gets an equal opportunity to present their requests and to have them granted. Another point I want to make here is that we know that the registry and some states parties have indicated a preference that defense requests be transmitted through the registry or via the chamber. And we do have some concerns about this. We are fully aware, we all are, that the Office of the Prosecutor is able to transmit their requests directly. And our position, as we transmitted it to states, is that defense requests for cooperation should be respected regardless of whether they're coming to a state party directly or via the registry or a chamber. So that's a really important point. Also for equality of harms. And then the last set of recommendations I want to draw your attention to are really more general, to ensure that states parties can really function as part of a joint cooperation effort. So there is, first of all, the recommendation to have a national focal point on cooperation. And this is something that the court and other states parties have indicated is really important to help requests get processed quickly and by someone who has capacity and expertise in the ICC. And then also states parties should be working with the Assembly to promote to work with the Assembly's efforts to promote cooperation. And there's some really important initiatives that they can also participate in, like the Focal Point Seminar on Cooperation. that will create what we hope will be a community of practice where they're sharing lessons learned and best practices about how to effectively process cooperation requests. And then the last recommendation from our program is that the states parties should establish a periodic review process for cooperation. And this would be similar to the Human Rights Council's Universal Periodic Review, but what we would like to see is more structure and accountability around state party cooperation. So under this idea, we would have around 10 states parties every year interacting with the Assembly, submitting a report, having that report reviewed, having civil society and others have access to that report, and then having the Assembly comment on it. And the idea behind this is, again, accountability around cooperation. So I'm going to leave behind the recommendations to state parties and just talk a little bit more about what else can be done. And I think one of the things that can be done is to understand better how cooperation works in practice. And this is my sketch of the structure of cooperation. And you'll see the ICC Office of the Prosecutor has recently, as we know, made a policy on cooperation and complementarity. They're now using a new structure, which is a forum on cooperation and complementarity to interact with states. Not a lot is known about this, certainly by external parties, because it's very new. The ICC Registry has recently created their Judicial Cooperation Support section, which I'll leave Anne to talk about. And in the states parties, we have the New York and Hague working groups, and in the Hague working group, the co-facilitators on cooperation and the focal points for non-cooperation. And this is basically where the decisions on cooperation with the Assembly, where the discussions are driven from. You'll notice that there's no defense representation on any of these. And I think that's something that we should look at a little more closely, because as was already remarked this morning, there's a real gap really for the institutional representation of the defense in a lot of these processes. So at the ICC, we have the Office of Public Counsel for the Defense, we have the ICCBA, and we have, of course, the Registry as the neutral service provider for defense teams, the Counsel Support Section. The idea that the defense should have a stronger institutional voice, should have a defense organ at the ICC is something that the IBA has supported and brought up for many years, including in the independent expert review. And interestingly, the experts found this idea to be quite persuasive. And it was not just the IBA advocating for this, it was others as well. The idea that the independent expert review put out was an expanded defense office centered around the OPCD, which would have increased powers, and the idea of the experts was to offer a strengthened voice to the defense on an institutional level, and together with the ICCBA, this could increase the institutional voice of the defense in the ICC and in institutional discussions with the ASP. It would have been a really great idea. And unfortunately, in the implementation of the independent expert review recommendations, this one fell by the wayside. I don't know how else to put it. And while it has been brought up a number of times, it has never received the type of attention structurally or from states parties that would have been needed to implement it. So unfortunately, we are still left looking for ways to communicate to states parties and within the court some of these really important defense issues that we've been discussing today. I just want to take a minute to talk about the agenda. Who sets the cooperation agenda? And here we have to come back to the ASP, because as we've discussed, the awareness of defense cooperation needs is really important, understanding them. And you have to understand also, we have a rotating cast of state representatives. So you have people coming who may not have been part of the discussions 5 years ago, 3 years ago. And so you have to have a constant project of reintroducing the concerns that defense counsel have to states parties. The facilitation on cooperation is driving the cooperation discussions within the Assembly and the Hague Working Group. the omnibus resolution of the Assembly, which is agreed on before the Assembly of States Parties, sets the mandate for the cooperation facilitation. And there is also a yearly resolution on cooperation. And there is, of course, acknowledgement that states parties need to cooperate with defense requests in these. But that can certainly be strengthened. And the need for states parties to ratify and implement APIC, all of this can certainly be strengthened. So, what else can we do? Awareness raising, as I was saying. States parties really need to continue to receive information about the challenges defense teams face in obtaining cooperation and the impact this has on fairness and equality of arms. The ICCBA can be extremely important in this regard and has really shown that advocacy done, for example, in the legal aid process has been very effective. So the ICCBA is one of the voices that we can look to. We need to keep raising, for example, the recommendation on the Defense Office or other ways to strengthen the institutional voice of the defense within the court. And lastly, within the ASP structure, there was a recommendation from the ICCBA and OPCD and OPCV that we have also adopted or endorsed, which is the idea of establishing a focal point for fair trials. So what would this do? It would give states parties a state representative who would be responsible within the ASP process to make sure that they're being informed and take appropriate action to address fair trial concerns. And it would be regular discussions about the matters that we've all been raising, including interim and final release, protection issues, relocation issues, supporting counsel, and dealing with the trust fund for family visits, and also looking at possible amendments to the legal framework and how those could affect fair trial issues. So I'll leave it there, and thank you very much.
Thank you, Kate. And I think if we sound like a broken record about defence access, I think it's key, and how we, as you pointed out, execute our request for cooperation. I think maybe something Anne will now discuss with us, how she's able to help with the execution of defence cooperation requests. Thank you, Anne.
Good afternoon. Yeah, it's working on both. Thank you for the invitation. I'm Anne. I work in the newly created Judicial Cooperation Support section. I'm actually the acting chief. This section was created in January this year, so we're still recruiting quite a lot of staff to be able to fully perform our function. I'm very happy to be invited today. That's my first attendance to your conference, and I know some of you. It's a good opportunity to see how we can strengthen indeed the cooperation for Defense Council. I'll try to explain to you a bit how we work from our perspective and the challenges that we meet, maybe have a candid conversation on the concrete challenges that we face also as registry to support you, so that we can have a more interesting conversation. So the role of the judicial, maybe the next slide. So the role of the Judicial Cooperation Support section, so we are placed in the registry, so we're a neutral organ, so we are to serve the chambers primarily, as well as the defense team legal representatives. We are part of the Division of External Operations, and we have 2 units. We have quite a small, actually, section, a Judicial Cooperation Unit, that's to support all the cooperation at the court. So we're talking about freezing of assets, for example, or how do we call witness to testify, a wide range of topics, and it's staffed with 4 staff members. And the Suspect at Large unit, this one was created specifically to deal with one of the most important requests for cooperation for us, which are the requests for arrest and surrender. As you know, at the court we have currently 30 arrest warrants or public arrest warrants that still need to be executed. So both organs, the OTP and the registry, felt it was really time to allocate maybe more resources to this topic, and that's why we have one unit now in the registry entirely working on arrest, and we have a number of challenges ahead. So when we come to judicial cooperation for defense team, the idea is that we would assist you in channeling your request for assistance to states or to the UN or international organization in general, to provide you with advice, to arrange for your meetings when required, and in general ensuring that the legal framework that applies for other staff at the court would also apply for defense counsel. I must say, to complement Kate's presentation, that maybe when talking about the registry, there's the consult support section. That's the one focal point for defense counsel for you to make your request. But there's other section within the registry that would also support your work. So my section, for example, for cooperation, but you can also think of the victim and witnesses section. Their role is to protect witnesses from the defense or from the OTP, or the country offices that play an important role in supporting your missions in the situation countries. So that's, let me give you maybe a few examples of the concrete action that we take, and maybe to insist on the fact that the support spans the entire case life cycle. So what I mean is that we continue to assist defense team during the entire trial, pre-trial. Recently, we were asked by state if we could facilitate family visits during the enforcement stage. So that was a first. I would say we didn't have any real obligation at this stage because the suspect was, or the accused person, was enforcing the sentence in the enforcement state of enforcement. But the state told us that if the registry was getting involved, it would facilitate the family visit. So of course we indicating that we would support. So that's one example of our work during the entire life cycle of the trial. I would say. Yeah. Some of the examples we had this year, we had to support a defense team getting a cooperation from a non-state party that took a lot of effort on our side. And to be honest with you, the issue that we had also is that a lot of what we do is then litigated before the chamber, so we also spend a lot of time in the hearings explaining how we have been supporting defense teams. This is how it should be, but it puts some maybe caveats or maybe restrictions on the way we can communicate with you if we know that some of the correspondence are going to be filed in the case file, so we have to put a lot of attention to this. So for us, that's something that we take into account. For family visits that we organize as well, so I don't know if you're familiar, but the regulation of the registry foresees that a detained person can receive family visits, but there's nothing in the legal text explaining how it's going to happen. So the registry created a trust fund for family visits so that we could get voluntary contribution from states. And it was a battle at the time because a lot of states were reluctant in talking about the topic because they were afraid that it would create a precedent in their national jurisdiction and that people would start to ask for financial support whenever they wanted to have a family visit when the family was in other countries. But at the end, we managed to put the right arguments forward with the assistance also of civil society. Now we have at least these voluntary contributions to be used, and the registry supports concretely these family visits. That means getting the visa for the family. That means organizing the entire logistics around these visits. In one case this year, that meant that the family had to travel through 3 different states so that they can arrive at the host state in the Netherlands. So there's quite a lot of resources, for example, that is put in that. And that does not necessarily appear when you read the report for cooperation and you just have the final figures. The you talked about it a lot this morning or today. That's a challenge for us, especially now to discuss release, temporary release, interim release, and final release. As you know, the Rome Statute was drafted in such a way that the rights are envisaged for the defendants, but unfortunately the practical part, which is how are we going to implement those, there's nothing in the text. Therefore, we have to put effort together with state parties to convince them that they either have to sign framework agreements on release or interim release or accept ad hoc requests. We've not been successful in that endeavor. We have only Argentina and Belgium that signed both agreements. And signing framework agreements doesn't necessarily mean that they will accept this person on their territory. It just means that they have the legal framework ready and they're happy to consider the cases. And as you've seen recently in the recent cases before the court, that we did not succeed in securing the states, which had an impact on the rights of the defense. This is something we are aware of, this is something we want to work on. That's one of the objectives of the new section, to work on this, on interim release. It's hard for us to find incentive for states to sign them. As Kate mentioned, this is unfortunately voluntary cooperation. And so we're looking at new methods to address these questions. One pathway that we are following now and trying to implement is to basically discuss release and interim release at the outset. So when we would have an arrest, starting to discuss immediately release and interim release, so that we have more time to find a final state. I think maybe what was not anticipated by the drafters of the Rome Statute was that a number of person would not wish to go back to the state of nationality. These states have an obligation to receive these persons, but as we need to take into account the views of the defendant, that has caused an additional burden, let's say. So that's voluntary cooperation. Of course, we work with states on a daily basis to ensure that the defense they take into account defense rights. We do that, for example, when we negotiate now the agreements with the situation countries. So each time the courts open a field office, a country office, we have an agreement with the host state, and so it's important for us that some provisions relate to the defense so that they're considered as the staff of the ICC, although they are independent. We also improve our practice with the UN over the years. There were a lot of ad hoc solutions found, but it was important for us that solutions could be found, especially the UN had specific requirements regarding the communication of confidential information to defense teams. So, for example, in certain cases, the UN insisted that the defense would sign an undertaking on confidentiality and that this undertaking would be filed in the case file, so that the chamber could have an overview of the agreements between the state, between the UN, and the defense team, and that worked well. So we were happy with this. I want to maybe insist on something that Kinga mentioned, is that we need to preserve, and that's a bit a tension between the registry representing defense team and the way defense team works, is that my job is to make sure that I keep the relationship with states. That's what I do, that's what I've been working on, because the relationship with state will assist one defense team, but also the other defense team. It will support our activities, the Office of the Prosecutor and the Chamber. And some of maybe the defense strategy might be not to be so keen on supporting the relationship because your interest, I understand, is to defend your client first. But sometimes there are tensions, and maybe something we can discuss on how the registry can make sure that it represents you to the best of your interest while preserving the relationship with the state. And as it was mentioned, for example, with Iraq, you have states that are very keen on cooperating with the court, and over time, as we're making mistakes, as we're asking, for insisting on certain requests for cooperation, that the relationship is fragile, and we need to pay attention to this. They do have an obligation to cooperate, of course, and this is not based on the UN Security Council as for a resolution as for Iraq. Nevertheless, as we know, the enforcement part of the Rome Statute is fragile, so we need to be pragmatic when asking certain things from states and take into account maybe more the context. And that's some of the lessons learned. I always forget mine. Yeah, one of the lessons learned for us is, of course, that when you send a request for cooperation, to take into account the context. For defense team, I sense a lot of frustrations when we don't get results, or at least when the requests are transmitted a long time after they've been sent. But in certain states, we can't reveal that because we don't reveal the request for cooperation from the other parties. But this is the same for everyone. So the request for cooperation, the time to reply is quite important. But you know this yourself when you go and meet with the authorities, you see that you yourself have difficulties in getting these results, and that's because of the lack of resources of the authorities. Sometimes, as Kate mentioned, it's the lack of proper legal framework. Once again, it's their responsibility to make sure that they have the legal framework in place, but again, we have to be pragmatic. Some focal points have indicated that when they receive too many requests for cooperation, they basically get flooded and are not able to implement. So we've been engaging to try and find solutions for this. For some states, they ask for support to deal with the request for cooperation. So we were looking with the country offices whether it would be possible maybe to have certain, maybe not staff, but maybe if we could recruit, for example, a visiting professional from the states that could be paid by the, let's say, the EC if we have this funding, but assigned to our focal point to assist them in dealing with the huge number of requests for cooperation. That could be one avenue. So we've been discussing this. There's still a lot of work to do. I heard Kate saying that it would be better that defense team go directly to the focal points. That's the right of defense team. It's unfortunately not what the focal points want. And from their perspective, instead of dealing with multiple defense teams, they want to deal with registry because it's always the same 3 person, because that's how many we are. We know the formatting, we know a bit the challenges they face, so they're more comfortable doing this. I'm not saying it's the best solution, and especially because we have limited resources, so we also have limited capacities. I would say, and here I'm not talking on behalf of the registry, but just as I was listening to Kate, thinking that maybe what would be useful if you don't get this defense office, which would one way to deal with this, is maybe to lobby for more resources in our section, to have one person who only deals with defense requests. That would be, it's not the best, but it's one alternative for you. I don't have a strict opinion on whether or not you should go directly to the focal points. I just say that when you ask us, registry, to channel your request for cooperation, it would be better if then we leave it aside. Because what we get a lot is that you ask us to transmit your request for cooperation, and then you follow up directly with the focal points, and it's sometimes confusing. However, I recognize there's a room for improvement, and hopefully with this new section, that's one of our goals is to improve the support to defense team. I engaged discussions with the OPCD and with CSS very recently, and I'm hoping that we can manage to provide you with more support on this. What did I want trying also on the legal basis. That's maybe something we want to discuss. When we transmit you requests for cooperation, states have no obligation to reply. That's also something on the legal basis that's weak when you send your request for cooperation, but you have an opportunity in the Rome statute to ask the chamber to endorse your request for cooperation, in which case the states have an obligation to reply to your request for cooperation. Sometimes what we try to do is to advise you on the practice of the state. So for example, if one state tells us, we're not going to reply to this request because we only want to receive requests from the chamber, then you make time. I mean, it's better for you to go directly for the chamber instead of trying something that we've tried with other defense teams. So we know how the state reacts. It saves you a couple of months, and I know you don't have this couple of months in your proceedings. So we're trying to advise. Of course, it's entirely up to you whether you want to follow the advice or not. Maybe you have another strategy. The registry, again, is not here. It doesn't know your strategy, and it's not here to replace defense, to replace counsel. So again, it's only an advice, but in my experience, that's, I think, good advice. That's why we give it to you. So I just conclude here. I'm happy to engage and have a reply to your questions. Again, yes, there's room for improvement, and we're very happy to discuss. But I wanted to tell you a bit about our own challenges within the registry. And yeah, thank you for the floor.
Thank you, Anne. And actually, we really appreciate your candidness and the frictions that you describe. And sometimes I don't think we get the balance right, how we kind of take on board a lot of what the state wants to the detriment of the defence rights. So I'll pass on to Phil to elaborate a bit more. I think this one is the one that works.
Thank you. Thank you all. Thank you for inviting me to this annual PowerPoint competition. This is my contribution. I want to start by saying that I acknowledge the 1994 Rwandan genocide and all its victims. It's not my intention to deny it. It took place. And what we found here is j'accuse, that's in relation to Emile Zola, a famous editorial against the unlawful jailing of Alfred Dreyfus at the end of the 18th. So what he was denouncing, judicial errors and lack of serious evidence. So that's what I'm doing. The one I'm accusing is the prosecutor of the MICT and the ICTR of repeated failure and reckless negligence in securing through cooperation key exculpatory evidence across multiple cases. And I will now lay my case, if you allow me. And this funny little drawing is whichever you want, an ICTR prosecutor and maybe a national prosecutor cooperating together with the results that we know together. So I will start with a bit of character evidence, if you allow me. Character evidence of that prosecutor. 2004 in Blaskich. Sir, you have to disclose exculpatory evidence across related cases. The appeals chamber. So, just a bit of a background. It's the relation of the prosecutor with exculpatory evidence seems to be like you're taking a piece to the slaughterhouse, and we will see that it has not improved over the years. So that's 2004. 2005 in Bagosora. Let us be clear if you have not understood what we told you last year. For example, if you have a witness who testify in different cases, then why don't you look up whether he has contradicted himself or said something different in the next case, and make sure you make that exercise and disclose the evidence if it so happened. You thought they understood after that? Well, here comes Bizimungu. 2011, few years later. And you can note, this was a case I was involved in. after having been involved in Zabonimana, and there were allegations across both cases, and the same prosecutor, a crook called Paul Narua, I'm calling him off here, who, when I told him in the Zabonimana case, who was the case that came after Bichamumpaka, when I told him that he should make sure to disclose the evidence of that witness who was saying completely different things about Bichamumpaka, who was waiting for his judgment, he told me that I was a young idiot that should not tell him how to do his job. Well, that's how the trial chamber reacted in Bizimungu, in paragraph 177. They blamed the prosecutor for their conduct in the Bichamumpaka case. I love maps, so I want to give you examples from a few areas of what took place. I'm going to continue with Bichamumpaka, because this was my first case at the ICTR. It's from Ruengeri, up there in the north. So in Ruengeri, we had two witnesses that were very problematic. The first one was GFA. I'm sure Kate will have good memories of our friend GFA. GFA testified in multiple cases at the ICTR and then wrote a letter to the president, to the prosecutor, to the defense, saying, well, by the way, I lied in many of your cases. So he came and he testified in Karamera and he testified in Bichamumpaka. And the trial chamber, in the end, they just decided to disregard his evidence rather than proceed with a full investigation, especially with the prosecutor proceeding with a full investigation of what took place. And you have this other witness in Bichamumpaka, witness GAP, who also admitted that he had lied, and we recanted, and de-recanted, and de-recanted, so it was not clear anymore whether he was maintaining his evidence or just withdrawing it, but in the end, another witness which the court decided not to consider in the acquittal of Bichamumpaka. And what is interesting in Bichamumpaka is that there is evidence that this fabrication of evidence is taking place in prison, is encouraged by Rwandan authorities. And you have peasants, from Rwanda coming to you and explaining to you the concept of corroboration. So these guys, they know how to plant beans and they know what corroboration is. And they are told what corroboration is, and they are told that if there's more than one person saying the same thing, then there are chances that gullible judges will believe them in Arusha. And that's what they did. In droves, they came to Arusha. The problem is that Bichamumpaka was not even in the country most of the time during the genocide, so that's something the prosecutor realized a bit late in the day. But in any case, that did not prevent him from bringing a lot of witnesses, putting him all around Rwanda during the period of the genocide. And this is before social media and Facebook and these things. So I had the honor, which I don't know if I will have ever again in my career, of bringing a witness who had actually been killed a few years before by the prosecutor. This guy was one of Bichamumpaka's victims. He was living in Liège, Belgium. Good health. And he came, and I asked him, I only have one question for you. Would you please comment on your resurrection? Because you were killed by this prosecutor in front of you a few years back. And the prosecutor had forgotten about that. He did not make the link with the early evidence. And I don't exactly remember what his reaction was, but that of the judge was actually priceless. So this problem of fabrication of evidence in the Rwandan prisons, of people, let's be clear here, people who had been detained there for years, for no reasons, and when they were given the chance of getting out by just giving evidence against one of these people in Arusha, a lot of them jumped on it and actually provided what the prosecutor was hoping for, which is evidence against the ICTR accused. That's an interesting decision we obtained in Zabonimana. We sought, because we interviewed witness GFA during the Bichamumpaka case. We met him he had fled Rwanda, and we met him in a different country. And he gave us a statement of several dozen pages explaining the mechanics of fabrication of evidence, how it's done, by whom, but this was for Ruengeri prison as well. And we were arguing in Zabonimana, a man who's coming from Gitarama, that the fact that they fabricate evidence in one prison should be of concern to the other accused as well. And at least a good decision that we obtained, where the chamber agreed not only that it was relevant for other accused, but for the public at large. And I have yet to see the disclosure of what took place in other prisons than Wengeri, where we all know it took place. I have a few friends here who were involved in the Girabatware case, who are fully aware of what was happening in Gisenyi, and that's not the only prison with those evidence fabrication manufacturers were in existence. Sorry, I'm dwelling on character, but I think it's important to know the creature I'm charging here, the prosecutor of the MIT and the ICTR. Kibouye. Kibouye is important because this is where Bicicero is. And Bicicero is where the French army intervened. So there was a lot of judicial activity in Bicicero. And another important area of Bicicero is the Seventh-day Adventist Church Hospital in Goma, where a lot of cases took place. The first case, Kaishema was the prefect of Kibouye. Rosindana was a businessman in Kibouye. Moussema was he was owning a big tea plantation. Bagishema was a bourgmestre. And Takutirimana, father and son, were the doctor and a pastor in the Goma Seventh-day Adventist Church. Enos Kagaba was the head of the nurse school in Goma. And then Mikam Limana was also in the area. Mpambara in Holland, he was the brother of Rosindana. Then for Bagosora and Dindimana, there were peripheral accusations. Mungwarere in Canada, he was an art teacher in the same village. And my first contact with the Kibouye cases was through Mungwarere in Canada, after all these other cases had taken place. And in Canada, I cannot charge that prosecutor because he worked diligently. He obtained the statements of the witnesses who had testified in these prior cases. And I had not the pleasure, but the disgust of finding out how these witnesses had changed their evidence over time and attributed murders and rapes and other accusations to successive accused. But you won't find that. You won't be able to find that out because they change their pseudonyms and they don't disclose and they continue. They seem to consider that these cases are vacuum sealed and that there's still today, in from 2009 until 2013, when we work in Mungwarere, that the evidence is there to own and not to disclose and not to work on. Mungwarere, the case of Mungwarere, actually, 2009, first accusations, was born in the case against Kagaba. These witnesses that used to travel in Dala and between Kibouye and Kigali, they all became Flying Blue members with KLM because they started traveling to the US, they started traveling to Holland, and now they were very keen on coming to travel to Canada. And this is where there's a real problem, because the prosecutor of the ICTR is solicited to provide evidence, to provide statements, to provide material about their witnesses and their identity and all of that. But it has never bothered asking to return the favor. Despite the obligations that we have seen earlier, never has the prosecutor made sure that these cooperation agreements with national authorities ensured the return of the evidence generated through their good offices. And that's where the problem lies, and that's why it's fundamentally a cooperation problem. So Kagaba, Minnesota, the poor man facing this judgment you will never find. The minute it was issued, it was put under seal by the American authorities. Don't ask me why. But it found its way into Ntakutirimana's case file, and that's where it is today, and nowhere else. So Kagaba doesn't know he's facing deportation, and at some point the judge is asking him, like, well, what's your defense? Who are you going to call? You intend to bring on witnesses and all? And he caused Munguare's pitfall, because yeah, there's this guy in Canada called Jacques Munguare, I'm sure he will come and testify for my defense. The day after, we have the first statements of a group of witnesses that go across all these cases, saying, yes, there's this genocidaire that we have forgotten to talk about, Mr. Munguare. And this is how the Canadian investigation started. There was never a word about him in none of all of the statements produced by the defense, by the prosecution witnesses before that. Another little funny anecdote about Munguare, we're preparing, and Philip's Gourevitch book, We Wish to Tell You That Tomorrow You Will Be Killed with Your Families. Well, it's based mostly on fabricated evidence from Kibuye. So he was announced as a witness in our case. And the prosecutor said, yeah, we want to call Gourevitch, contextual evidence and all that. And I said, you can bring him on, but I'm going to use all the evidence to show how his book is shit. But I will never renounce my right to cross-examine him. He did not come, unfortunately. So anyway, sorry, but it's important to, it's unfortunate that the prosecutor is not doing that job. It's really unfortunate that to this day, it's not doing that job. This is Ntakutirimana trial judgment in 2003. The defense alleged in their defense, as part of their case, this case is the result of fabricated evidence. And they put all the witnesses that are part of this evidence manufacturing process. Rejected by the trial chamber and the appeals chamber. February 2003. Kagaba, a real judge, hearing shit Rwandan evidence. I regret so much you don't have access to the findings of that judge. He was so turned off by this. And you know who backed him up in his findings? Alessandre Desforges. She was a witness in that case, and she told that judge, this is preposterous. The comments, there's 10 pages of evidence analysis by that judge, which are so damning for these Rwandan witnesses who were part of most of the prior cases at the ICTR. But it's under seal. And you think the prosecutor was aware that their witnesses were going there. Some of the statements are actually part of the record. They did fuck all to obtain any of that evidence, and this is a judgment issued in 2003, 21 years ago. That evidence still has not made its way into the ICTR or the MICT records, so that the accused there could actually see for themselves whether there is remaining exculpatory evidence that would undermine their own case. So that's Kagaba. There's a significant credence to the respondent's claim that the case against him is the result of a conspiracy to fabricate evidence. It's the same witnesses. What the defense was saying in Ntakutirimana, it's that. Munguare, 10 years later, same thing, same witnesses, same group, same fabrication, same stuff. The judge arrived at that conclusion. And it would be fun. I don't know, maybe Vincent Sabine Foura and Samuel Ndagujimana are protected witnesses. I don't know. I'm not going to talk about that, but they were not, there was no measures of protection for the witnesses in the Munguare case. And the conclusion of the judge, after hearing all of the evidence in Munguare, the survivors of Goma have fabricated evidence together. That's in the judgment for everyone to read. You think the prosecutor did something? You think the prosecutor tried to obtain the record, the case file of the Munguare case in Canada? Never. No efforts. And they know that. I made a motion to appoint an amicus curiae after the evidence came out that there was fabrication of evidence, and one of the prosecution witnesses admitted that. You know, you'd think the prosecutor would, ooh, this is bad. Let's make sure we go to the bottom of this and let's try to investigate that. You know what they did? They tried to conflict me out of it. You're conflicted. I'm sorry you're conflicted. It's not the first time that they had done that. They continue to this day to try to conflict me out of cases. But the reality is that that's 2 cases in a row denouncing or arriving at the conclusion that there is fabricated evidence from survivors of the Goma area. There was, I'm going to skim quickly. So, Nitigeka, connected case, one of the witnesses in Canada forgot that he had attributed 2 very specific murders to Nitigeka. Very enthusiastically come into the Mungware case and attributes one to Mungware. So there was a review procedure going on in Nitigeka, which stopped after Nitigeka died, unfortunately. Takutsirimana, for the trial chamber, the collusion, even if there are 2 cases arriving at that conclusion after we issued our decision, well, not really a new fact for review, right? Not sure we want to get into that. So there was the recent review procedure in Takutsirimana, which was last week actually, did not contain any possibility to reopen the issue of fabricated evidence. Butare, that's my new playground. I'm just starting now. So let's see what we found out. Happy to... Desiree Munianeza is Milen's. So let's see. I suspect we're going to have a great deal of fun. I'm assisting in the case of Nchimie in the United States, and you can see the number of cases that we're going to have fun to play with. So that should be an interesting, because from what I see so far, the prosecutor has adopted the same attitude. In all those cases, there's nothing that was done to see if in the Butare, Nyahamasu, Ko, Nizeimana, Wamakuba was acquitted. All these witnesses that said that he was at the hospital, which is a key feature of all these cases, the Butare hospital, were found to have lied or were not believed beyond reasonable doubt, and Wamakuba was acquitted. And what I know so far is, there is link. A witness came in Munianeza in Canada to where he admitted that he had lied at the ICTR, he had lied in Canada. So same kind of story, this time in the Butare prefecture. I have to go fast, I'm sorry. And if you want to read it, I can forward it to you after the conference. So what am I charging the prosecutor with? At least something light, like maybe he's breached his code of professional conduct, especially the last part of it. Demonstrate respect and candor before the tribunal, and not knowingly to make an incorrect statement of material fact or offer evidence which prosecution counsel knows to be incorrect or false. Should prosecution counsel become aware that a statement made to the tribunal is incorrect. They know that there is evidence in those foreign cases that undermine their convictions, and they're not doing anything to get it. Last week in Arusha, we had a review hearing. Last minute, urgent motion. The prosecutor has just obtained, in 2024, 11 years after the Mungware case, the evidence of the investigator for the defense in the Mungware case. It took them 11 years to do something about it, and they were asking for delays to be able to produce it and make sure that the trial chamber could have a look at it. We're talking about cordial relations, Kate, between defense and prosecutor. I'm not known. Rashid, not sure, But what I want to say is that after the Mungware case, if we had a real officer of justice handling, working for the prosecution of the MICT and the ICTR, what is it to send an email and ask me, where should we go? What should we have a look at? What do you advise us to do to make sure that justice is done and that we can remedy to these wrongful convictions if they are? Nothing. What they do instead, they charge me of having bribed the whole defense witnesses in the Mungware case. They could stop. That's true, Milan. That's their theory, that I bought all the I bought all the defense witnesses. That was part of their submissions last week. So,
on a legal aid salary.
yeah, exactly. So, and they should start with the prosecutor in Canada when you realize, I'm finishing. The prosecutor in Canada, when they realized that their case was shit, he went himself and he cross-examined all the ICTR witnesses. Just read that. Just ask for this. Just ask to read and consider how a real prosecutor, honest in Canada, after he found out that the case was a result of fabrication, went there and took them one by one and confronted them with it. Just see that and act on that. So you're talking about success, failure, challenges. For me, it's utter failure. That we're still in 2024 and that this evidence is still dorming in Canada, the US, or Holland. It's a failure, and it's a failure to get exculpatory evidence. It's a risk that there are multiple wrongful convictions for these people that went through the ICTR and the MICT. And I would even label it as a deliberate obstruction of justice because they fully know what the evidence is and where it is, and they do nothing to procure it. It's not me who's conflicted, it's them. It's them who are conflicted, who don't want to get that evidence and don't want to take any risk that these cases be reopened and that we need to relitigate all of that. I'm sorry I've extended my time, but I thank you for your attention.
I now regret not using the sunflower, but it was really interesting. So thank you, and it really shows us how we need to ask the right questions for cooperation and how some of the issues perpetuate. And so I pass on to Brent to give you time, although I don't think you need to speak on behalf of the prosecutor, please don't. But last but not least, please go ahead with your remarks.
Good afternoon, everyone. It's late in the day, and it's tough to follow a zealous advocate like Philippe, so I'm going to be really, really brief. The life cycle of the mechanism, we're obviously in a different place than the ICC, and so while we have provisions on cooperation, etc., I'm just going to focus really quickly on a few more operational, or let's say day-to-day aspects of cooperation, which are relevant for my role in terms of legal aid and defense matters at the mechanism. I'm going to be really brief because it's already late. So we've got a handful of areas that basically on a daily basis I'm working with a number of people, including Philippe. Actually, he's somehow involved in more cases at the mechanism than anyone. And so I deal with him more than anyone, for better or worse as the case may be. We've got logistical, administrative, financial, and legal issues that are just day-to-day cooperation for me and defense teams that I work with. In terms of logistics, authorizing official missions for defense travel, assisting them, troubleshooting as the case may be. We recently had some travelers, for example, that got held up at a border checkpoint with WhatsApp. In modern day, you can get a message immediately, so we were able to troubleshoot that, and it actually was kind of a blessing in disguise, let's say, that they got held up at the border because a laptop was left on the plane, and that allowed them time to get the laptop, given that they were held back a little bit. But point being, I cooperate regularly with defense teams on these types of issues. Moving beyond logistics, administratively at the mechanism, and again, obviously we're at a different place in our life cycle. We've only got a handful of cases left, so there's not near the caseload maybe that other tribunals have these days, but ensuring defense teams have access to the network, printers, scanners, just the really day-to-day basics of assisting them, facilitating their work, access to the detention unit, facilitating appointments as the case may be. In terms of a mix, let's say, of administration and law, Philippe touched on the notion of conflicts of interest, and that's actually one interesting point from my perspective in terms of the assignment, appointment, or recognition of counsel and support staff. By and large, those types of decisions, especially when it's support staff being assigned to support counsel, is pretty straightforward. But every now and then, the notion of a conflict of interest comes up, and that's when it gets a little more interesting and outside of the routine, let's say. Philippe referred to a recent allegation of a conflict of interest, so that involved a little bit of work from my side on the registry. Financial cooperation. I mean, this is a big ticket item, obviously, for the defense. At the mechanism, we've had our policies in place for years, so there's not a whole lot really to talk about there other than to distinguish between the types of cases that call for, let's say, lump sum remuneration versus hourly payment. When we find gray areas that haven't been touched upon, or when a unique situation arrives in a case, we do our best to try to good faith negotiate, quite honestly, with the defense to find a pragmatic way forward. End of the day, and to maybe try to end on a bit of a positive note, for me, one of the key lessons that I've learned in recent years about cooperation is just the notion of communication. I really think it's the most important thing, and I'd like to just give an example in the sense that obviously there's certain issues that need to be raised, for example, before chambers in a more formalistic way, in writing, etc. However, and to take a step back from that, I would just encourage people to find a different forum, let's say. Have a cup of coffee with someone, take a walk in a park. I know that sounds a little bit silly, but my point is, a lot of times I think we find ourselves in stalemates when it comes to issues that require cooperation. And my experience has been that when you take someone out of the setting that they're in, maybe you get to know them a little better, maybe you just change up the forum. You can have breakthroughs. And to use Phil as an example, I mean, I think him and I, in a 5-minute phone call, typically will achieve a lot more than we would exchanging emails and formal correspondence where the tone and the tenor of a conversation can get misinterpreted, or it can just be overly formal, and you don't have the opportunity to speak frankly. And so I would just encourage everybody to try to find a way to break through the impasse if and when you have those moments, because with patience, and I think with trying to apply a different mindset to a problem, you can probably find a way through it. I think I've been under 5 minutes. I'm going to call it a day there. Thank you for your time.
Thank you, Brad, on behalf of all the panel. And particularly, I agree, sometimes we build walls for no reason. We are over, but it's up to you, and I know we do have the GA, but I will allow 1 or 2, unless you all want to go home, then we end now. But if there are 1 or 2 pertinent questions, then I think there's 1 at the back and 1 at the front, and then we'll call it a day.
Thank you. I'm concerned about the discovery process at the stage of the trial. To what extent does the court really help the defense team in conducting its own investigation regarding the evidence, or does the defense team rely only on the evidence turned over by the prosecution and start the process from there? And I think that question would likely go to Phil as a trial lawyer.
Phil, you're on 2 minutes though.
You have every right to be your right to be concerned. Your right to be concerned, but I can reassure you that we can do our own investigations to some extent, of course. You know, it's not always easy, and there are obstacles, but it's not acceptable the way the ICC works in terms of disclosure. That there's real. I mean, we discussed that earlier on this meeting. There's a need for real access to get a defense perspective on the work of the prosecutor. If I can, put it at its simplest, there is a real need, and investigations are possible. We can be funded for that. I mean, of course, there's always grievances in terms of how much we get, but yeah, we can do. We have the possibility to do independent investigation. I don't know if that answers your question, but it's important actually to do it. It's a key component of all work.
Thank you. Take a second question.
Thank you. My question is for Kate and Anne-Laure. I just want to go backwards. At the ICTR, we had the Office of External Affairs and Cooperation, and it was headed by Roland Musuga, and we, the defense team, had a direct access to that office. All our cooperation requests were going through him. He was extremely helpful with the defense teams. I received loads of material through cooperation requests. When I arrived at the ICC, you would think there's more out there, so obviously your cooperation request will be executed more swiftly, you'll receive more material. It's the opposite. First, I'm not allowed to speak directly to Anne-Laure's office. I cannot send you a direct email, I have to go through CSS. So I have the impression that there's again a step backwards, because as if the defense is somehow going to disturb you too many times, or we have to go through CSS who doesn't really understand what we're doing because they're an administrative support office. So that's my first question. Why can't we have a direct access to judicial cooperation? Or why doesn't, because I heard what you were saying, you're a limited team, you don't want to jeopardize the relation with the states, your primary focus is arrest warrants or assisting chambers, so the defense come after. So why isn't this all sent to OPCD? Because we have, I mean, I heard what Kate said, what the independent experts said. It's more efficient through OPCD, because I received cooperation responses where the state responded to your office saying, we don't cooperate with the defense, we cooperate with the ICC. But if you are our voice, well, you have to fight back and say, it is through the court that we're asking you to cooperate with the defense. It's not a private party. So I have the impression that we went backwards from the MICT or the ICTR, and I am concerned that the registry is not fighting for the defense to have equal cooperation access. I received a response from the special court of CAR saying we don't cooperate with the defense, so I couldn't have access to the material. The Office of the Prosecution signed a cooperation request, a cooperation agreement, and you pointed it out, I think, Kate, with CAR, with the special court. Why isn't the registry doing the same for the defense? And if they can't, send everything back to OPCD so they can take the fight for us.
I think I'll let Anne, if you want to respond. Can we write to you directly?
No, thank you. Thank you for the question. My name is Anne-Laure, and that's where I see that we don't speak enough together. If we can get to that, at least you would know my name. We've discussed this direct access. Actually, I discussed it with Marie also, and that's something that we could consider. I know Roland also, and he's been assisting me on certain aspects, so maybe I would also have a discussion with him to see how they were dealing with defense team in the other tribunals. Yes, there's a limited number of persons. We are fighting for the defense. There's a lot of actions that we do that maybe you don't see. I'm not sure about going through the OPCD. I would want to have a more general discussion, with everybody involved. That's definitely something that we've been looking into also with the former president of the Bar Association, to see what role we could give to them. I understand the frustrations. I think that one of the starting points would be more communication, more transparency on our hands, maybe to tell you how many phone calls, how many requests, how many times we go and see with the focal points on your behalf, that you don't see that. With respect to the same access as the Office of the Prosecutor, the problem I have, and I think that's something that you could discuss, is the legal basis on which we send your request for cooperation in this Article 93. The Article 93 foresees that the court can send a request for cooperation, but if you look at the Rome Statute, the court is not the defense. And therefore, when we endorse your request, for me there's a gray zone, and that's why we sometimes encourage you to go directly before the chamber, because if the chamber endorses your request, there's no question with states, and we could push back. We had some pushback from our own chamber saying you can't send this request for cooperation on the legal basis that it's mandatory cooperation, because that's not what the Rome Statute says. And we can discuss some of the case law that I'm happy to share, the case law that is public. That's also something that we can work on. A lot of the decision of the chamber on specific requests for cooperation coming from the defense is confidential. So I know the chamber, I know I'm bound by it, but I cannot maybe share it with you. And that's something we could work on. So yes, let me, maybe since I'm here, it's a new section and I hear what you're saying, why don't we meet next year after the Assembly of State Parties and see what we can do to improve the communication at least. Yeah, looking forward to the discussion.
Okay, just a couple of things. Milan, we completely agree. I mean, this is the point about the independent expert review and the missed opportunity there, because at one point the IBA did a survey of structures of council support across hybrid and all kinds of tribunals, and at a time when the STL was still fully in operation. And the Defense Office innovation is something the ICC really missed out on. There is a value to having defense-specific support in the institution with an institutional voice that's undeniable. The fact that it's not in the statute and it seems impossible to shoehorn in it now should not change the fact that it has value. So this is why I said we keep pushing for it in some form, and we can't let, the ICCPA has access now with being a recognized body by the ASP. The OPCD has a spot. We've got to keep those spots and we've got to use them. I won't say anything to duplicate what Anne said, but I will just say, one of the points that we made in drafting our recommendations to states parties is that the Rome Statute, Article 93, for example, no, it doesn't specify the defense. We're saying in domestic legislation, you should. You're not bound by what's in the statute. You can implement better legislation in your national legislation. You can specify cooperation with the Defense and Victims Council, and that's what we're saying that they should do specifically for this reason. So when there are areas where states parties in their national legislation can improve on what was not clear to the drafters of the statute or what couldn't pass through that political process, they are free to do so, and we recommend that they do so. I'll leave it there. Thank you.
Okay. I don't think there are any more questions. Oh, there is. Okay, one more.
Hi. At the risk of being very unpopular and asking a question at the end of the day, it's directed, my name is Eric Tully, I'm counsel at the KSC, and it's directed to Kinga. I worked on the capacity building project as an in-country trainer for the judiciary, where we're explaining international fair trial standards to local members of the judiciary. That included investigative judges and defence counsel. And I'm not too surprised you didn't hear much from the defence counsel. They're very much frozen out from any type of involvement in the process, except to beg for mitigation at the end of proceedings, but that's a separate matter. I'm interested to hear from you about criticisms that we heard from members of the judiciary about UNITAD. They obviously would voice their concerns to us, but it wasn't really the focus of our work, so we didn't really engage with them because we simply weren't interested. We were there for a very specific job. But one of them was in relation to the sharing of evidence with third parties, and they referred to the case in Finland. I don't know anything about the case, and this isn't a veiled putting forward of my views. I have no idea what the criticism was based on, but they felt there was an exclusion of victims specifically. Now, the first question is basically, did you hear that criticism yourself, and can you shed some light on what it was that they felt irked by? And the second question I had was about the non-inclusion of international criminal legislation in the national standard. Now, whenever we dealt with them, we were talking to them about the international conventions that some would be quite surprised to learn that Iraq has signed and it has ratified the ICCPR, but they constantly pointed to their own codes to say, well, this is enough, this is sufficient, and it covers all of the rights. so there's no need for anything else. So I'd imagine you might have felt the same, you've heard the same from them, but what I'm interested in is what efforts did UNITAD go to, if any, to push for a change in legislation, or was that something that was just seen that was to be too far outside the UNITAD's mandate, which I guess would be understandable, but I'd like to hear if you can shed some light on that too. Thanks.
Sure. I think this is not easy. Thanks, Eric, for those questions, both very interesting. So, as I said in my presentation, initially the Iraqi judiciary was very happy to cooperate with UNITAD, and they shared massive amounts of records with us. However, the problem was that we never gave anything back, not even information, let alone evidence that we collected. And the Finnish case is actually, it's a very, very painful one. And it happened in the investigation that I took over. So it happened before I joined UNITAD, but I'm acutely aware of it. It had to do with twins, two Iraqi citizens who ended up in Finland, and they were accused of participating in a spiker massacre. And the Finnish prosecutor sent a request of assistance to UNITAD, and UNITAD conjured up some evidence, circumstantial evidence of the involvement of the twins, but they never really engaged with the Iraqi investigative judge, Judge Kozai, who was actually investigating that particular case. So his complaint, with which I completely relate, was that if he had had a chance to look at the file that UNITAD prepared before it was sent to the Finnish prosecutor, he might have been able to add certain records or to point out certain gaps in the evidence that was provided. But what UNITAD did, asked the investigative judge to provide whatever evidence he thought was relevant, and then added their own records. But instead of preparing a joint case file and discussing it and maybe seeing what evidentiary gaps were there, they just unilaterally sent it to the Finnish prosecution. And the Finnish court found that there was no, it wasn't beyond reasonable doubt that the two twins were involved. Lo and behold, a few years later, one of the twins was arrested in another case, and he said, oh, by the way, I participated in the spiker massacre. So I think this case encapsulates the disappointment of the Iraqi judiciary with UNITAD, that they gave us records, but we never really worked with them together. I have to say that towards the end of UNITAD's existence, there were some efforts to build joint case files, but they are less than the fingers on one of my hands. So that was again too little, too late. And as for your second question, remind me.
Efforts made to.
Yes, exactly. So actually, UNITAD was involved with the Legislative Council in preparing a legislation that would incorporate the three crimes into the domestic system. And to go back to your question, it's with the Iraqi parliament, it was always a bit unclear to me how they saw the applicability of international instruments into their domestic legislation, because while for the human rights covenants they would say, oh, they directly apply, we don't need any other legislation. For customary international humanitarian law, they would say, well, that actually doesn't apply directly, only treaties apply. But the Constitution doesn't make that very clear. In some constitutions you would say that treaty and custom applies or only treaties apply. Their constitution is not very clear, so they took the position that there has to be a domestic law that incorporates these crimes. And UNITAD for the past 2 or 3, now I think from 2020 to 2022, actually participated in an effort to draft this legislation, but then it got delayed by the parliamentary committees, so it was never brought in front of the Assembly, and to this day it hasn't been adopted yet, but well, there's always hope. Thank you.
So I just want to say thank you to the panel, for all of you for patience and listening. I think it was really informative and interesting. I think communication, as you
announcements. The ADC members, please remain. We'll be doing the General Assembly in just a moment. I'm getting the online portion up and running now. Everyone else, we have our annual party this evening at 7:30 at Susie Q Bar and Restaurant. Again, that's Dr. Leila Kada, number 337, or Tweede Haven, the second harbor. Hope to see everyone there. It's a really good event, good chance to ask questions you didn't have a chance to ask today, to meet people, network, and have a really good time and have some beverages that are better than drunk. Okay, thank you all for coming. Hope to see you all this night.